The social worker has told you that they want to terminate your parental rights. This is the selection and implementation hearing. Come with me and let me explain how you might be able to fix this horror story. If you haven't regained custody of your children by the conclusion of the 2-1F hearing, the court will schedule a hearing pursuant to Welfare and Institutions Code, Section 366.26. The hearing is supposed to select the best permanent plan for your children. The first plan of the social worker is likely to recommend is going to be adoption by another person. Generally, this person is a foster parent or an unfriendly relative. Adoption means that the person or persons become the legal parent of your children and that you and your family have no more rights or interest in the children. You lose the children forever. When a relative adopts the children, that relative becomes the parent. You have no rights to visitation with the children, and if you are to see the children in the future, that will be at the sole discretion of the new adoptive parent. Unless you were to win an appeal, an adoption usually cannot be overturned. It may be theoretically possible to bring a lawsuit to overturn an adoption, but it is highly unlikely. The second plan that the social worker could recommend is legal guardianship. Under this plan, you remain the parent, but the legal guardian becomes the permanent caretaker of the child until the child turns 18, making all decisions about the child. You may have the right to visit. Most likely these will be supervised or monitored. You may have the right to overturn the legal guardianship and regain custody of the children out into the future, if you are able to show the judge that you have solved the problems that originally brought you to the juvenile dependency court. You need to discuss this option with a competent attorney. Lastly, the third plan the social worker may recommend is long-term foster care. Under this plan, the child remains with the foster parent, relative, or family friend until the child is 18 years of age. This plan is rarely used these days, and in most cases, social workers opt for the more favored plan of permanency, which is adoption. So why do I share this great information with you? I share this information with you so that you will know what can be done when things go wrong in the courtroom. I realize you're likely seeing this because you have questions or concerns about your own case. If your matter happened here in California and you're thinking about your situation, I invite you to pick up the phone and call me. You know, I answer questions like these almost every single day, and I'd love to talk to you. You can reach me at 888-888-6582 or email me at v@vwdlaw.com. We will file the right legal documents and briefs to give you the best chance of getting your children back. That's it for today's video. Have a wonderful day.